wait a second.
These are not your notes.
Where did I leave my notes? That's a good question. There's a folder somewhere. Okay. You didn't take it with you, Mary Ann, did you? That looks like, I think.
Sorry about that. Adding some excitement to the evening.
Okay. Okay, thank you so much for your kind introduction and for your kind welcome. It's lovely to be in Vancouver. They've been working me kind of hard, so that these are my last official duties tonight, and tomorrow and Friday I get to be a tourist, so it's going to be fun to see parts of the city that I haven't really had time to look at. I've read about in the guidebooks, okay, and so I've heard about from some of you. So thank you so much for having me here, and I'm deeply honored that you would. I love it's a fantastic program you have going to be able to bring in scholars in the business law area and to be able to create these opportunities for exchange among scholars and for your students to hear from other people, and it's my great honor to be able to be a part of it, and I appreciate it. What I want to talk about today is boards of directors, okay, and what I want to start off by giving you some puzzles that I see in a lot of the corporate governance talk, okay? This is the conventional wisdom that we find about boards of directors that I think is a little puzzling. The first bit of conventional wisdom says that boards of directors should be independent. Yet there are dozens of empirical studies out there that have failed to find any kind of consistent evidence that the structure of boards or board practices have any effect on corporate performance. Okay, so this has been this research has been going on for almost 30 years. There's lots of evidence on all sides, but nothing that people have been able to find that's replicable in the next study. The second bit of conventional wisdom is that we have boards of directors criticized. There's an ongoing criticism of boards of directors that they tend to be passive, ineffectual. They aren't on the job. Things happen on their watch that go without getting caught. This is sort of the conventional sense of what boards of directors do is apparently not very much. And yet, corporate law almost universally in the United States and in every other country that I know of requires that corporate powers shall be exercised under the authority of a board of directors. Okay, that seems to be a consistent part of the package that corporate law provides. So why does corporate law require board governance? What is it about board governance that is thought to be so great when we can't find any evidence that they're making any difference? Okay, what is it that we think directors should be doing? Okay, should they be independent? And if so, why should they be independent? These are important questions that I think we need to address. And I just want to toss out some ideas tonight that will maybe stimulate some thinking in that direction. So unless you've been on another planet for the last few decades, you probably have heard that boards of directors are supposed to monitor management. This is the big charge that people talk about extensively, okay? And let me just give you a sample. So this is from a Canadian corporate governance specialist, Dr. Richard LeBlanc, as he was quoted in Canadian Business back in February. The board of directors has a role to control and monitor management and take the reasonable steps to ensure compliance. When scandals happen, people look to the board as to whether it properly monitored management. Okay? This is from a publication called Corporate Governance Monthly, and it was a little regular feature in that publication that is put there by the Deloitte, some division of Deloitte. Deloitte, they broke up Deloitte and it's their consulting into their business that does this. Monitoring corporate performance is a critical function of every board. A key aspect of the board's oversight role is to actively monitor management's execution of approved plans, as well as the organization's progress toward meeting its objectives. So I looked around to see what I could find. This is the benefit of Google here. So I wanted to what do they say about this in Canada? And I came up with the requirements the criteria, the director's assessment criteria that are part of the Office of Superintendent of Financial Institutions of Canada. And so this is their statement on what they think boards of directors of financial institutions should do. The board of directors is responsible for providing stewardship and oversight of management and operations of the institution. Its key responsibilities include, and then there's a whole list of reviewing and approving of this and a reviewing and approving of that, and providing for independent assessment of and reporting on effectiveness of organizational and procedural controls, monitoring performance against business objectives, strategies, and plans, and it goes on in that vein. Okay? From a very prominent UK corporate governance expert whose name is Paul Davies. Okay, this was something he published in 2000 that was published by the OECD, actually, in a report that he prepared for the OECD. In the U.S., where corporate governance movement began, and in the UK, where considerable attention has been given to this topic over the past decade by 4 high-powered committees, it is clear that corporate governance reform is seen as being addressed to the principal-agent relationship between management and the shareholders. Both the American Law Institute's Principles of Corporate Governance and the UK Listing Authority's Combined Code focus unambiguously on this problem. The issue, as stated, is how to provide an appropriate level of monitoring of management in a universe of dispersed shareholders. In the U.S., we've had several rounds of reform in the last decade and a half in response to issues, shall we say, that have arisen. There was first Enron and WorldCom and a series of scandals in 2001 and 2002, to which Congress responded with the Sarbanes-Oxley Act, which ratcheted up the requirements for boards of directors. We've had the Dodd-Frank Act that was passed in the wake of the financial crisis of 2007-2008, and we've had the Federal Corrupt Practices Act has been expanded, so the responsibilities get ratcheted up about what we expect boards of directors to do, all of this having to do with monitoring management. CEOs and CFOs and board chairs now have to certify our financial statements. We have expanded the MD&A requirements. We've expanded the CD&A disclosures. We now have say-on-pay voting requirements. Board committee, they're now required to have certain committees have to exist on the board, and those committees have to have charters. So there's all these mandates. There's new federal whistleblower protection measures in place now. So there's a tremendous emphasis on monitoring that has taken place in the last 10 to 15 years. Really, it's been building up for longer than that. And I think it's been driven by 4 developments. The first is the principal agent thinking that has become dominant in corporate law scholarship, okay, and in business and management fields as well. Although it's not as dominant in the management literature as it is in the legal literature, it's quite dominant there. And this was indicated in the quote from Mr. Davies that all of these reforms are about improving the monitoring job of directors. Okay. A second development is that in the wake of the evolution of Delaware case law, since the decision in the Caremark case, okay, and that's an important landmark case in which the Delaware Chancery Court articulated that we expect boards of directors to have in place the systems that are going to be able to alert them if there's illegal activity going on in the company so that they can prevent it from happening. So the emphasis there is on preventing illegal behavior rather than maximizing share value or some of the other things that we think we have to monitor managers for. The Enron and WorldCom cases shone spotlight on boards of directors. The what were they thinking, what were they doing question was asked in the wake of those scandals. Where was the board? How could these frauds have been perpetrated right under the nose of boards that were made up of people with pretty strong reputations? What was going on? And then, of course, the financial crisis brought attention to the duty that directors have to not only monitor the actual activities of management, but also to monitor that risks that the corporation is taking. That risk management has come to and risk monitoring has come to the fore as an important function of boards of directors. Well, in response to all of this, we've had tremendous amount of board reform going on, okay? Boards have added independent directors. They've been setting up board committees that have explicit monitoring duties. These have been in the areas of audit, risk, nominating, and compensation committees, all of which has to do with monitoring. And that this activity has, there's been a lot of change that's gone on in boards. And I serve on the board of a nonprofit, and even though we're not covered by Sarbanes-Oxley or by any of these requirements, our board is constantly looking at what we should be doing. So I think boards of directors have taken these reforms to heart. They're looking at what it is that they're supposed to be doing, and they're continually getting the message that they should be monitoring, okay? Nonetheless, we have 30 years' worth of empirical research that has failed to find consistent evidence that any of these specific board structures, whether they have a special committee or don't have a special committee, whether they're only independent directors on those committees or not, whether there's more than 50% of the directors are independent or not, whether there's more women on the board or not, they have not been able to find a consistent relationship between any of these structural or activities structural, by board structure, I mean the committees that they might have, or the composition of the board, meaning who serves on the board, contribute, or practices in which they have a systematic review at certain times of the year of everything that they're doing, whether they contribute to corporate performance. So what's wrong with this picture? Okay, why aren't we seeing the increase on board performance leading to better, on board monitoring, lead to better corporate performance? And I would suggest tonight that we may be looking for the wrong thing. And I'm maybe overstating my case a little bit, but I want to get some ideas out here, okay? Well, what else should we be looking at? I would present to you that boards have another very critical function that has kind of been neglected in all the emphasis on monitoring, okay? This is the role that boards of directors play in making the kinds of decisions for the corporation that are fraught with uncertainty and conflicting interest, okay? The kinds of decisions that boards are required to make by law or that get bumped up to the board in the first place are the decisions that are fraught with uncertainty and conflict of interest, okay? I call it making the hard calls. This is what the board is there for. The board is there when a problem can't be solved at a lower level and the decision it has to go up to the directors. Now, this comes out of work that I've been doing for about 15 years now on a particular kind of problem that is called in organizational theory the team production problems. So the idea is that many organizations involve some kind of productive activity that requires a team of people who have to work together in order to achieve some output. And the inputs can be complex, difficult to specify in advance. It's hard to write a contract that's going to govern the relationships among the members of the team, because you can't specify in advance what you need from the team members explicitly. At least you can't specify explicitly enough to be able to contract over it. And you can't tell after the fact who was responsible for what. It's a team output. It's called a joint output. It's the product of all of these different efforts, okay? And so it's hard to split it up and say, so it's hard to write, it's hard to create contracts that emphasize incentive compensation. So it's hard to measure after the fact who was responsible for what. Such teams are fraught with incentive problems, okay? So how do we deal with those? Well, the early research on teams suggested that teams needed a monitor, okay? And that the monitor's job was to make sure that none of the team members were shirking, and that this monitor should also be the owner of the assets that are used in production. Okay, this was the theory, that would help solve the problem in team production. This is why, okay, this in fact is why this kind of an argument was made back in the 60s and 70s, and it was presented as why capitalists should own the means of production. Okay, we want the owners of capital to also monitor the activities of the team members. However, in subsequent years, the question became more pressing as to what if the team members have to use very highly specialized skills and knowledge? You need something from those team members that you can't necessarily get from some other source. Okay, your team input, the labor input, if you will, is not a commodity. You're going to need something special. Okay? Well, subsequent work on organizational theory suggested that having a boss who owns the firm and calls all the shots might not always work out so well, because you're going to have to inspire and bring those team members along in ways that that might not be obvious. Okay? If the monitor captures all the surplus that's generated by the team, why should the other parties contribute fully? Okay? On the other hand, if the monitor monitors too intensely, team members may spend too much time and energy trying to curry favor with the monitor so that they get a bigger piece of the pie when the pie is divided up. There's also evidence from recent research that suggests that if the monitoring is too intense, this will suppress the sort of intrinsic motivations of the team member. So it's not obvious that monitoring is the sum total of what boards of directors should do. I propose instead, and I have in some of my scholarship, an alternative solution to the team production problem. I didn't originate this, but I sort of brought it over from economics and applied it to the case of boards of directors. Okay, this is an alternative solution that at first may seem counterintuitive, so hang in there with me. This solution is you want to delegate downwards as much as possible. So to the extent possible, you want the team members to work out the division of labor and the division of surplus. But inevitably, there's going to be conflict. When a conflict arises that the team members can't resolve, then some outsider has to have the ultimate decision-making authority. Okay? That outsider, again, counterintuitively, should not be a member of the team, should be external to the team. That outsider needs to have hiring and firing and compensation rights, but should not own the underlying assets. If they own the underlying assets, then they are subject to incentives that can be counterproductive. Okay? I won't bore you with all the sort of theoretical modeling and all this kind of stuff that arrived at this, but this is the bottom line from this body of research. Now, I say it's not as crazy as it might first seem. Okay, we see outside decision makers in a lot of contexts: judges and juries, referees in sporting events, arbitration, mediation. It's a well-known phenomenon that we use an outsider to make the decision in certain kinds of situations. What these examples have in common is that the party who has the authority to decide in a complex situation is not a member of the team, is outside the team. And I would argue that this structure helps to encourage all of the team members to work out their issues rather than having the decision get bumped upstairs. They don't want it to go upstairs. They want to decide it at the level of the people who know most about what's happening. They don't want an outsider to be able to make the call. Okay? Example. How many big, high-stakes legal cases have you seen in your lifetime in legal practice, and have we heard about in the news, where they ultimately settled rather than taking it to a jury? The parties know that ultimately they're probably going to be better off if they decide it themselves than they are if it goes to the jury. Okay? I think corporate law is an institutional framework that potentially achieves something similar to that, if it's structured right. So in my scholarship, I've talked about this as the team production theory of corporate law, and I argue that an important role of boards of directors is to be the ultimate decider at the top of a hierarchical structure. The board acts on matters that can't be resolved below. In a crisis, for example, when there's great uncertainty and conflicting interest, that's when the board of directors is called upon to step in and deal with the problem, bring it to some sort of resolution. Okay? It might not always be an optimal resolution once it reaches the board. Okay? And that's key to how I'm going to connect this to empirical research that's been underway. So the team production theory emphasizes that the board's job is to make the hard calls. And it's important that boards of directors are not part of the regular team. They're outside of the team, okay? They try to keep track of if they're doing their job, they're trying to keep track of what's going on with the team, because if a crisis happens, they need to be equipped to deal with it, okay? They don't own the assets, okay? The corporation owns the assets. So board members can't sell the assets out from under the other team members, and that fact means that some of these perverse incentives that could get into the system don't happen. They do have hiring and firing and resource allocation duties. No individual board member can exercise these duties. Okay, the board can only act as a board. Individual board members do not have the authority to act for the board. Okay, and I would just like to point out that I have borrowed from theory of the firm, which in economics means why do people organize themselves and carry out activities in organizations rather than do it individually and interact through markets. Okay, and applied that to corporate law, and I would argue that and I've done quite a bit of this work with Professor Lynn Stout, who's now at Cornell, is that what we have is a theory of corporate law, not a theory of the firm generally, but a theory in particular of why we have the structure of corporate law that we do. So what difference does it make? So what are some of the implications if we think about corporate law from a team production perspective rather than a principal agent perspective? Team production theory emphasizes lateral interactions among the team members and the various incentives that the team members have to work out their problems themselves, to reach a solution in terms of who contributes what and who gets compensated what among themselves. Okay? And this is, as I said, because nobody wants the decision to get kicked upstairs. This is not good. If the decision gets kicked upstairs, this makes you look bad. Okay? If you can work it out, you're all better off. The role in this story of the hierarchical structure is not so much about monitoring as it is it's their job to decide on actions or strategies of the corporation in the face of uncertainty and competing interests. And that's when, for whatever reason, the matter can't be resolved down below. Professor Stout and I have called this the mediating hierarchy function. I wouldn't stand up here and tell you it's the only thing boards of directors do, but I think it's been an important task, an important component of what directors do that has been missed and overlooked in all the emphasis on monitoring. Okay, so the theory, I think, suggests some ideas for empirical analysis. The first is that the team production framework is supported by the historical role of boards. So I want to take some time tonight and just talk to you about what I've learned about the historical evolution. Where did this idea of board governance come from? As I said, it's virtually universal in corporate law around the world. Where did this idea come from? I think it could also, this approach to thinking about the problem could also provide some insight into why we haven't seen that board structures and processes necessarily show up in the form of measurable improvements in corporate performance. I also think there's a really interesting question here as to whether understanding the role of boards of directors might be more consistent with the way boards of directors are viewed in countries other than the U.S., outside the U.S. I'm not sure about that. I'm going to talk mainly about number one and just say a little bit about the implications for empirical, for why the empirical studies haven't shown us what we thought we were going to get from them. Okay? So where did this idea come from? What's the origin of board governance? The earliest corporations that we've been able to, historians have been able to identify, were used to create a mechanism so that property in churches and monasteries and religious institutions could be held in perpetuity. Okay, so that no one individual owned the property, and so when the abbot at the abbey died, you didn't have to worry about who the abbot's heirs were. Okay, you had to the property was owned by the abbey. It wasn't owned by whoever it was who was managing or taking care of that property at any given time. And so property could be accumulated and dedicated to these quasi-public kinds of institutions. And the corporate form was first used to provide some independence and mechanism for holding property in religious institutions, churches, and monasteries. The other place it was used in these very early on was in providing for self-governance of particular geographic units. Okay? So townships and boroughs might get a charter from the king, and the charter said that whatever goes on within the walls of this town is self-governed. The king and his authorities are not going to come in and tell the town what they had to do and who had to be the mayor or any of those sorts of things. It was going to leave this entity to self-governance. So the charter was about granting self-governance rights to a particular subunit of a geographic unit. Within those geographic units, the governance boards were elected by members. Their job was to pass ordinances, enforce them, and to resolve disputes within the territory. The earliest commercial corporations were what were things called regulated companies. And these existed in England and Netherlands and maybe some other European countries in the 16th century. And I don't know for sure about other countries, but we know they existed in England and Netherlands. Okay, I know at least, and I'm sure there are scholars out there who know more about it than I do. These organizations were more like guilds. Okay, they had members, not shareholders. Okay, and they followed a one-person, one-vote governance rule. Okay, the charters were valuable because they granted monopoly rights to the members of this guild, if you will, the members of this company, okay, so that they were the ones who had the authority to trade in certain regions. So there was one that was granted the rights to a particular group of merchants to trade with the North countries, meaning Scandinavia and that part of the world, okay. And basically, the charter said nobody else can compete in there. It was a grant of monopoly rights. Okay. The merchants in these regulated companies continued to carry out their trading activity in their own right. Okay? They didn't pool their resources and carry out a common trading mission initially. They all continued to trade, but the guild or the company that they were part of, it had the role of protecting their monopoly rights, so keeping encroachment, preventing others from encroaching on their territory, creating the ground rules by which the people within the guild would interact with each other, and resolving disputes among the members. Okay, the members of these regulated companies would elect a council or board of assistants. The word assistants was used a lot in the early literature, and their job was to write ordinances, to govern the activities of the members and keep non-members from encroaching, and to adjudicate disputes that arose among the members of the company. Sometimes the governance, the king or the sovereign that had granted the charter would say, okay, we have the right to put 1 or 2 or 3 office holders on your council, just to keep track of what you're doing and report back to the king. Okay, the king was never given enough rights to control the enterprise, and they were protected from that by the charters that granted them a certain degree of self-governance protection. Okay, the earliest joint stock trading companies were ventures that arose out of these regulated companies. Okay, you've heard of joint stock companies, and basically the boards of those joint stock trading companies just administered the monopoly rights. Okay, that's what they did. That's what their purpose was. By the mid-17th century, the merchant members began pooling their resources. Okay, and say we're going to carry out trade missions as a group rather than each of us individually trading in our specified territories. So we're going to pool our resources and maybe send out 3 or 4 ships that will go together. This will improve the probability that some of it will return home safely if we pool our resources and send out several ships rather than each of us send out separate ships. Okay? Late in the 17th century, initially what happened was that when these ships would come back, they would unload the goods that had been collected and distribute them to the participants according to what each of them had contributed in the way of financing, and then they would go their separate ways. And they would reform again if they wanted to do another trading mission. Okay? Late in the 17th century, these companies began to say, we should retain some of the money we made from this individual mission so that we can begin to re-equip the next mission. And they began to think of themselves as having an ongoing basis. So there was the contribution of the individual members became a joint stock. Okay, they kept the stock in the company, and they used that to fund the next round of the trading activity. Okay. The role of the board in these things was basically, once they began to do that, then the role of the board expanded to include determining the strategy that they would pursue about, say, which countries that they would go to, or how would they deal with disputes, or how would they deal with political issues in the countries they were trading with. The board began to deal with those kinds of things, and to carrying out the business of the combined enterprise. In the late 18th and early 19th century in the U.S., the corporate form was adopted to be used to fund things that were basically public works projects of one sort or another. Okay, these were charters that would be granted to business people to establish a bank, an insurance company, or to build a canal or a road or a bridge or some kind of, or waterworks or some kind of public works project of that sort. The charters were granted by the state governments because in many cases the state governments had tried to carry out these activities by the state as a government function, and they would lose money. Okay, and this was politically not a good idea for the state to be losing money on its ventures, so they privatized. So this was an early round of privatization in the United States. Was these the states began to say, okay, we'll grant the charter and we'll give this group of people monopoly rights to carry out this activity, in exchange for which they have to agree to build the road or build the canal or put up sufficient resources to be able to fund a bank. Okay, the boards of directors of these organizations typically included people who represented the interests of the customers of the firms, not necessarily certainly not only of the investors in the firms. Okay, this has come from the recent work out of Professor Hansman at Yale and a young Brazilian scholar he's worked with, Mariana Pardendler. They have gone back and they've looked at these boards and they've said these boards are boards that were put in place to protect the interests of the customers. Why? Because these projects were constructed primarily to provide services that the merchants needed. They needed the bridge, they needed the road, they needed the bank, okay? But they wanted to be sure that somebody wouldn't get control of that enterprise and then use it to discriminate against them and charge them too high prices. They wanted to be sure that they were going to remain competitive in their ability to use those services. So they had to put people on the board that were going to protect their interests as customers of the service. They weren't expecting to make money on the service itself. So they weren't expecting these ventures to make money per se, but they needed to be able to be as customers of those firms. They needed to be able to use them to facilitate the business that they were in, the primary business that they were in. Having a board of directors became then a standard requirement for corporate charters to be issued in the by the early 19th century. Later in the 19th century, we had a trust movement, very late in the 19th century. Huge monopoly firms were organized by financiers and industrialists who brought, these were put together by bringing dozens of smaller companies together, and they would pool their resources, and the way they did it was that they used a trust mechanism. Okay, in 1882, shareholders of about 40 refinery companies contributed their shares that they owned in these companies. They were all very small little refining operations, to the Standard Oil Trust, which was governed by a board of 9 trustees. Why did they do that? They wanted to control competition, obviously, that's part of it. But part of the reason they did it was that they needed to get control of all of the refineries so that they could eliminate the inefficient ones, okay, and concentrate production in the most efficient refineries. So that meant some of these participants were going to have their refinery closed. Well, they didn't want to do that if their interests weren't going to be protected by the trustees, who were going to be sure that the earnings of the trust were distributed fairly among all of the people who contributed shares in these small companies to the trust. Okay, so the role of the trustees was, in part, at least, to make sure that the interests of these shareholders, they were shareholders of the member companies. They weren't shareholders. There wasn't a big company at the time. There was only this trust. Okay, those had to be protected. Okay, we know that the trust mechanism was cumbersome, and that when the state of New Jersey decided to put in place a law that allowed a corporate law that allowed a corporation to own shares in other corporations, then the holding company structure became possible. And New Jersey later changed their rule to make it more strict, but then by that time Delaware had put in place the same rule, and that's the explanation for why Delaware law has continued to be so powerful in the United States. So by the early 20th century, a substantial share of the big industrial holding companies that existed at the turn of the beginning of the 20th century had been formed in this way, by smaller companies being pooled together to form a big monopoly or oligopoly firm that controlled large parts of the industry. They didn't need much outside capital. They had a lot of capital already from the contributions of each of the individual business owners. Okay. The boards mainly consisted of owners of the individual businesses who then joined the board of the combined business, and they often became managers in the combined business. Okay? The financiers, who might have represented other shareholders, really weren't involved that much at this early stage. These boards were more likely to focus on decisions about investment, expansion, marketing, new product development, labor relations, all of these other kinds of issues, and they had less of their energy and resources was devoted to paying much attention to what the shareholders wanted or needed at the time. Then in the 1920s, we had a period of very rapid growth, but during that period in which money was being made, mostly the shareholders were happy about that, so they didn't have to worry too much about shareholders. But what was happening was that shares were becoming very widely distributed. Lots of individuals held shares who may not have been part of that original company that was merged, or who may have bought shares in the market in different kinds of ways. The stock market had become quite active. There was a lot of trading activity, so an individual investor could buy shares in these companies. By 1932, Burley and Means said, as we know, famously, they observed that ownership had been separated from control. These corporations were now being managed by professional managers who didn't necessarily represent the interests of particular shareholders. And what did Burley and Means say about that? They said, if the corporate system is to survive, the control of the great corporation should develop into a purely neutral technocracy, balancing a variety of claims by various groups in the community and assigning to each a portion of the income stream on the basis of public policy rather than private equity. In other words, we want these big corporations to be governed by mediating hierarchies, whose job is to make sure that the proceeds of the enterprise are distributed fairly among the community and the participants. In the 1960s and 1980s, up until about the 1980s in the United States, this was the conventional wisdom about what boards of directors do. They would describe their job as being about balancing the competing interests of customers, employees, and communities. They needed to provide a return to shareholders, but no one said anything about maximizing share value. Business Roundtable in 1981 published a document which said that balancing the interests of constituencies was an integral part of the corporation's decision-making and management process. They listed the constituencies in that document, and it included customers, employees, communities, society at large, suppliers, and shareholders listed in that order. Okay. So what do we make of this history? Historically, it's clear to me that the board role was about administering, balancing, and resolving disputes, and not so much about monitoring. Some monitoring had to take place as part of that, but a substantial part of their focus was on trying to administer and balance the competing interests. Now, of course, history is not the end of the subject. Just because we did it one way in the past doesn't mean we do it that way now. But I think it's worth paying attention to the wisdom of business leaders who preceded us, at least when we think about some of these kinds of problems. What's happened since the 1980s? Well, we all know. Financial markets have become very active at keeping pressure on corporate boards to focus on maximizing share value. We've had finance-oriented scholars that have argued that this is the job of boards is to intensively monitor managers to make sure they're maximizing share value. These finance scholars and finance practitioners have gotten quite a bit of support in this activity from institutional investors who have decided that that's a good idea. So they will throw their weight behind activist shareholders who are in there pressing boards of directors to constantly be maximizing share value. But I think it's worth remembering that this was a change in the norms. This was not the norm going into 1980s. It has become the norm since then. So much so that by 2004, John Reed of the New York Stock Exchange, he was the chairman of that. He was commenting on the role of boards and the business world in the wake of the Enron and WorldCom and Tyco scandals. And what he said was that the mantra of shareholder value was enshrined in companies, boardrooms, analyst reports, and the business press. Stock price became the measure of performance and self-worth. And he was commenting that he thought that he didn't think that was such a great idea. Now, so what does this tell us about the effect of these changes? What is the empirical evidence? I mentioned we can't find any evidence that these changes that have taken place since the 1980s are necessarily correspond to improvements in corporate performance. There's been hundreds of books and articles that have been written about what boards do, about what boards should do, about what effect they have on corporations or what the supposed effect they have on corporations. Economists and finance scholars have tended to focus almost exclusively on this monitoring role because that's consistent with the story we've told ourselves that it's about a principal-agent problem. The other roles have been identified, but those tend to come out of the management scholarship rather than economics or finance. And they've suggested that the other role that boards have is to advise management. They're supposed to be a source of wisdom for these are the gray-haired types whose job is to bring experience to bear and provide wise advice to a corporate CEO, to connect the firm to needed resources, and to enhance the reputation and credibility of the organization. Surprisingly few studies focus on the decision-making in conflict situations that I'm emphasizing up here. Yet case law and stories in the media constantly provide examples. Okay, you've got a case where you've had a big industrial accident. The BP production platform blows up. Okay, what is the board going to do about it? Initially, the board doesn't do much of anything. They try to see if they wait. They see whether Tony Howard can resolve the problems. Turned out he couldn't. So they had to get rid of Tony Howard and bring in someone else. Okay, a CEO has to be terminated, or a CEO dies unexpectedly, and the board has to step in and figure out what to do. Okay, they're going to be in a conflict situation. There's going to be competition within the firm for that position. There are going to be factions that have formed. Okay, somebody high up in the company gets accused of sexual harassment. That's a case where the board has to get involved. Okay. Suppose there's some sort of revelation, and you've got to figure out how the company is going to respond to some sort of revelation of an accounting fraud that took place. Board gets involved in that. Okay. The law requires the board to make the decision about the corporation's response to a derivative suit. Okay. High level of conflict going on. Board has to make the call. Routine decisions such as dividends and CEO compensation. These things involve a lot of conflict of interest, okay? And these are places where the boards are required to make the decision. How's the corporation going to respond in the event of a takeover? Again, highly conflictual situation surrounded by a great deal of uncertainty. That's where the board is called upon to make the call. These are all examples in which the board has to make a very difficult call in the face of competing interests or in crisis situations. Okay. So we've had all this empirical research, and it's basically been inconclusive. There have been a lot of intriguing findings individually from one study to the next, but there's no consistent findings that are replicated or supported in other studies. I've done a little survey I've been surveying the literature on what people have found in these empirical studies, and we haven't completed this. This is just some very preliminary findings. We found 7 studies that show a negative relationship between the percentage of a board who are independent and the financial performance of the firm. We found 4 studies that show a positive relationship, and we found 5 studies that show no relationship. And this is typical of every particular category of idea that's been tested. Composition of the board seems to make little or no difference in the financial performance. There is one exception, okay? Corporations with more independent directors, especially if they're on the audit committees, do seem to have significantly fewer incidents of financial misstatements, earnings manipulation, abnormal accruals, and financial fraud. Okay, so that seems to be an important change that's taken place. Okay, does this mean boards don't matter? I don't think so. Okay, a key function of boards is that they serve as a somewhat neutral outsider to the team production process. Ordinarily, they don't get that much involved in the day-to-day decision-making. In fact, team members should have an incentive to solve the problems at the lower level. So we don't see much effect on in day-to-day ongoing performance of whatever the board is doing. Okay? But they do become involved in crises. In such situations, boards are going to face great uncertainty. They're likely going to having to be balancing different interests and trading off and finding out who's, how the factions work and who needs what in order to get satisfied. If the implications of the decisions that the boards make in these situations were clear, they would have been made down below. They reach the board precisely because they're unclear. Okay? Boards get involved because it couldn't be resolved below, or that it involves some sort of serious conflict of interest for the management. Their role is to make the hard calls. There's no obvious right answer when they make those calls. Okay? So we might expect then that when we look at empirically, what we would find is that whatever the board is doing, it's making the decisions that are right on the line. Okay, it's making these hard calls, and it could go a little bit this way or it could go a little bit that way. Nobody knows quite where the line is, that they would randomly deviate from some kind of hypothetical optimal decision. If that's correct, then we wouldn't expect to see that the board activity correlated with board performance, with the performance of the corporation. So boards matter because the existence of the board and the authority vested in it helps team members solve their team production problem. Team members can make credible commitments to each other, not to shirk or expropriate too much, wealth from the joint production activity of the enterprise. But because if the behavior of any of the team members gets to be too egregious, that team member can be fired or removed. But the board has to have authority for this threat to work. Okay? Which makes me skeptical about proposals that are going to take authority away from boards and give it directly to shareholders. Boards have been around for a long time. They've been an important part of the way businesses have been organized for centuries. They're required in virtually every country, and I don't think it's an accident. So I'll stop there. Thank you.